single day. I'm gonna make something great. That's my way. Every single day, I'm gonna make.
Hi! How are you?
I'm fine. Shan, I have a problem.
What's the problem, Binti?
I have an assignment.
What assignment?
Assignment to explain the separate legal entity of the company.
Oh, I see. So, what should I do for you?
I need you to explain the concept of separate legal entity to me so that I can do the assignment.
Oh, sure. Binti, what is the concept of separate legal entity? It comes from effect of incorporation. In section 20 says that once a company is incorporated, it is a body corporate having a legal personality separate from its member and continue in existence until it is removed from the register. Under this concept, a company will become a body corporate that exists separately from its member and directors. In other words, the corporation is an entity just like human being, being created using a legal and official purpose. The moment the company is incorporated, it is a body corporate, and the corporate will drop to separate the company from its member and officer. The company exists on its own capacity and can make a business. It can generate income and revenues, can incur losses, and then can hire employees and pay for its own taxes. So, it is better to recognize the company as a separate legal entity because the owners can enjoy the limited liability and risk based on their investment stock. A separate legal entity has its roots in the landmark case of English House of Lords in Solomon against Solomon and Company Limited. So, Titi, I will tell you one story about this case that are related to the concept of separate legal entity. So, once upon a time, under Solomon against Solomon Company Limited. So, the court held that Solomon was neither under liability to Solomon Company nor to the creditor of Solomon Company, and Solomon debentures were validly issued. Therefore, what I can conclude from the case of Solomon's, the Solomon case is famously regarded as a landmark in the UK's company law, since this case has been established fundamental principle related with company law. And then, according to the Solomon case, a company is both an association of its member and a legal person separate from its member and directors or officers.
Oh, Shan! Yes, thank you! But now I can relate with the case of Lee and Lee's family, right?
Yes, like that lah.
On the point of where companies can contract with the members, directors, and outsiders. It was indeed developed in the case of Lee and Lee's farming. In this case, Lee has formed Lee's farming and become a director. However, he was killed in the accident while carrying out his work as a pilot, and his wife claimed for the compensation. And the court held that his wife entitled to claim the compensation since Lee and company considered as a separate legal entity even he worked as a controller of the air farming company. Here, Lee could enter into a contract with the company and could be an employer also. Now, I can summarize up to 4 points based on proposition that incorporate companies have a separate legal personality. First, company property is company property. Second, company debt is company debt. Third, company can contract with the members, directors, and outsiders. And last, company can commit tort and crimes, so that company can liable on its own, not its the member, since the member as the company is separate legal entity.
2 hours later.
Hello, good morning, Miss.
Hi, good morning, Binti.
Miss, I have a question for the assignment.
What question?
Question July 2017, question 1, B.
July 17.
Yes, ma'am.
Oh, question 1B.
Yes.
On the impact of corporation, right? Okay. What is it?
I didn't understand the question and I don't know how to explain it. Can Madam help me?
Oh, okay. No problem. I will explain to you later.
Okay, Madam.
Okay,
Thank
bye.
you.
Based on the question, I can highlight an issue which is whether Ace Bank can sue Zura personally as per effect of incorporation. Okay, Section 20 of Companies Act 2016 provides a company incorporated under this act is a body corporate and shall A. have legal personality separate from that of its member, and B. continue its existence until it is removed from the register. Separate legal entity is the moment where the company is incorporated, it is a body corporate, and the corporate will withdraw to separate the company from its member and officer. Maksudnya kat sini, bila company tu ditubuhkan, akan ada corporate will yang memisahkan antara member dengan company itu sendiri. Separate legal entity ni boleh dikaitkan dengan kes Salomon vs Salomon and Lee vs Lee Air Farming. For perpetual succession, a company shall continue its existence until it is removed from the register. Company is said to be continue its existence or continue in perpetuity despite of death, insanity, bankruptcy, or even change of member. Maksudnya, company tu perlu diteruskan walaupun dekat dalam company tu ada member yang dah mati, ataupun gila, ataupun bankrupt, ataupun member dalam company tu sendiri dah berubah. Kes yang boleh dikaitkan dengan perpetual succession adalah renewal techno holding. Next, Section 21 of Companies Act 2016 provides that a company shall be capable of exercising all the function of a body corporate and have the full capacity to carry on or undertake any business or activity, including to sue and be sued, to acquire, own, held, develop, or dispose of any property, and to do any act which it may do or to enter into transaction. For Section 21, Subsection 1, Paragraph A of the Companies Act, enables the company to sue and be sued on its own name. The company is capable of enforce the section because of the doctrine of separate legal entity. Maksudnya kat sini, company tu boleh saman dan boleh disaman atas nama dia sendiri. Tapi member dalam company tu sendiri, dia tak boleh saman on behalf of the company, and orang luar pun tak boleh saman member tu sendiri dalam company tu. Kalau orang luar nak saman company tu, dia perlu saman atas nama company tu sendiri, bukan atas nama member tu. Kes yang boleh dikaitkan dengan Section 21 Subsection 1 ni, kes Force vs Hamidon.
So for the application, we have three. We can refer to the case of Solomon vs. Solomon Co. Ltd, where Solomon is a majority shareholder and debenture holder because he has 20,000 £1 share and also 10,000 pound debentures secured by floating charges. But eventually, the company faced financial problem and become insolvent that it had to be dissolved. During liquidation, company's asset were only £6,000. So the companies owed Solomon £10,000 of secured debentures, and the other creditor is £7,000. The issue here is whether the debenture originally issued was valid up to the point that the priority is above the unsecured creditor. So the unsecured creditor claimed that the remaining £6,000 asset of the company should be settled for the creditor. But since Solomon is the owner of the company, so he is liable for his own debt of 10,000 debentures. Unfortunately, the court held that the corporate veil separates Solomon and his company, that it became two separate persons. So the business is basically owned by the company, and the debts are the liability of the company itself, not Solomon personally. So the remaining assets should be used to settle Solomon's debt of 10,000 debentures in priority over the unsecured creditor. So in this case, LMZ Sdn Bhd is the separate legal entity from its members. Okay, so for number 2, case of Renewal Tedman Holding Property Ltd. So there are two shareholders, of which a husband and wife. So one day they both are involved in an accident and both died, but their infant child survived. So the company still exists despite its member died, and the shares of the company shall transfer to its beneficiary, which is the child. So in this case, for LMZ Sdn Bhd, it shall continue its existence even though there is only one member left in the company. So the third one can refer in the case of Horse vs. Hub Hotel. There are two shareholders that claim the rest of the directors of the company that has misapplied and improperly use of the company's property until the company suffered losses. So the court held that two shareholders cannot take action on the directors since the injury complained of was an injury to the company. So the company must sue the directors. The two shareholders that wanted to sue the other directors, they have to sue those other directors as a company. The conclusion is Ace Bank should sue LMZ Sdn Bhd instead of Zura as an individual, because Zura borrow the money as a company, not an individual. So yeah, Binti, I hope you understand.